Why did you ultimately decide that you didn't need to obtain a clearance?
I don't honestly remember right now, but at the time, the strategy seemed sound and rational, and it made sense.
This lawyer had never tried a case before. Was 2 or 3 years out of law school. This is a case that needed a lawyer who had done 100 trials. The government had 4 highly skilled, highly trained lawyers on the prosecution side. It's just a punch in the face, to think of a lawyer with no experience attempting to defend this case. Her heart was in it, but frankly, there was a kind of hubris and ambition that blinded her. She said that she had to learn on the job. When someone is facing, the rest of their life in prison, you don't have a lawyer who has to learn on the job in order to defend them. And those are her words. What was your thinking on why you were qualified to represent Hamid in this very serious case?
I thought that it could work. I thought that, even though I had never been in a criminal courtroom, I felt comfortable in the courtroom. I thought it was something I could handle if I had some guidance on just the procedural stuff. And I was willing to learn it. I was willing to get in and do it.
Brendan was the first case that I got assigned to as a law student, and it changed my life. When I got assigned to Brendan's case and watched those videos, I knew that's what I wanted to do. I had to help people like this. I now teach the same class that I took 10 years ago. It's kind of come full circle for me.
Brendan is going to have a very difficult time prevailing on his case as it stands now. And it's not any poor lawyering on Northwestern's part, it's the AEDPA statute. It is the death knell of federal habeas law. And they did it to get rid of pro se prisoner petitions, but they gutted the habeas writ. And everybody knows that does this work. You can't win these things in federal court. You'd be better off to come back 1,000,000 times on successive petitions with the trial court in the state court than you ever would to darken the door of the federal courthouse.
It's just flatly impermissible under all the Supreme Court's precedents.
Your Honor, I am not asking for the creation of new law. I'm asking for this court to apply decades-old law.
Identifying criteria and things that the cops cannot do. There is no case that says they cannot do those things.
I am not asking this
You're
court
asking us to use this case to establish that new benchmark for investigators in interrogating juveniles. There is no case law to support that. Under established law, under 2254D, you must lose.
The motive of the police was to get a second killer?
I'm sorry, Your Honor?
What was the motive of the police in doing this? To get a second killer?
Your Honor, the test does not direct us.
No, I know that's not the test. That's the question I'm asking you.
The record doesn't speak to the motive of the police in this case.
You're arguing their motive.
I am not, Your Honor. In fact, the district court here, in granting relief, pointed out that the police may well have simply failed to appreciate the way in which their words landed on Brendan Dassey. But it does not preclude relief under the principles of Miller versus Fenton.
So they needed two killers.
No, Your Honor, they needed the truth. But the problem with this interrogation is that the way in which they pressured and pursued Brendan Dassey was in direct contravention of the seeking of the truth.
When were the shell casings found?
In November of 2005.
In the garage?
In the garage, Your Honor.
I think you're about to run out of time. If you would like to wrap up.
All right. If there are no further questions at this time, I would ask this court to affirm the district court's grant of habeas relief.
All right. Thank you very much. Mr. Berg.
We're on habeas here. This is now the 6th time that a court has reviewed this case.
It's that misperception, and it's the opportunity to correct those things. And so I think if the defense had a better grasp of the facts of the forensic evidence, that would have been very powerful. And when the one judge said, well, why do we need 2 killers in this? The answer to that isn't to avert and not answer it. The answer is, I'll tell you why, Judge. The reason wasn't to have 2 killers for the fun of it. The reason was to take down Steven Avery. They needed someone else to corroborate what the forensic evidence refuted. Just knowing all that, being able to refute it all. It's like there's this big tidal wave coming towards you, and you have to be able to knock out the whole thing. You've got to have an impenetrable wall up where you can just deflect everything they come up with. Everything has to be answered. And when you leave an oral argument and you have not answered on a confession why those are not unique facts, you're in trouble.